If the House or Senate certified a contempt citation against current or former White House officials arising from the U.S. Attorney investigation, would you permit the U.S. Attorney to carry out the law and refer the matter to a grand jury as required by 2 U.S.C. 194?
In order for a U.S. Attorney to take a charge of contempt to a grand jury, the U.S. Attorney has to be able to tell that grand jury that any reliance by the contemnor on a privilege cited by the President or on an order of the President was unreasonable. Unless the U.S. Attorney can say that it was unreasonable for the person who is proposed to be held in contempt to have relied on a privilege or an order of the President, that would be, that person cited for contempt can't be found to have had the state of mind necessary to warrant charging her or him with criminal contempt. And therefore, that evaluation is going to have to be made by the executive when, as, and if it happens. I hope and pray for a lot of things. One of them is that I don't ever have to make that decision. But when I make it, I'm going to make it in line with the principles I've just discussed.
Your predecessor made the decision without even looking at those principles and said that the U.S. Attorney wouldn't be allowed to go forward, and the White House did. You would at least require some principles before making such a determination. Is that what you're saying?
That's what I'm saying. I'm going to be guided by the principles I just mentioned.